Mr. President, distinguished members of the court, it's an honor for me to appear before you on behalf of the Swiss Confederation. The terrorist attacks perpetrated by Hamas and other armed groups on the 7th of October 2023, firmly condemned by Switzerland, and the ensuing violent confrontation in Gaza are today in all our minds. They contribute to polarizing even further positions within the international community and undermine the prospect of a negotiated two-state solution. This potentially makes the task of the court more arduous, but also more necessary than ever. Our presentation will not concentrate on the terrible events of 7th of October and the situation that flows from it, but on the legal questions as posed to the court on 30th December 2022, which relate to the status of prolonged occupation. Israel has legitimate security concerns, but also the obligation to comply with international law. Similarly, the Palestinian people has the right to self-determination with the aim of living in peace, and Palestine has the obligation to respect international law. And fair and lasting solution can only be achieved on the basis of the rules of international law. A good understanding of the content of the obligations under international law is therefore a precondition for negotiating a solution that reflects the legitimate interests of both parties. Thus, it's therefore essential to better understand the legal questions relating to measures taken within the framework of the prolonged occupation of Palestinian territory. The opportunity for the court to provide an impartial response based on international law to the questions posed by the General Assembly and thereby provide a basis for a negotiated solution therefore remains essential. My oral presentation will focus on the specific issues linked to the prolonged occupation under the angle of international humanitarian law and human rights law. Moreover, I'll refer to our written submission of 17 July 2023 and to the developments contained therein. The law of the occupier and the legality of occupation are two distinct questions. The law of occupation applies independently of the question of the legality of occupation. Occupation is a situation that is governed by international humanitarian and human rights law, whereas the legality of it is governed by the UN Charter. The potentially illegal character of an occupation must not call into question the fundamental separation between jus ad bellum and jus in bello. The right of occupation continues to apply in Palestinian territory, irrespective of the question of the legality of the occupation. As such, the prolonged character of an occupation has no incidence on its conformity with jus in bello. No provision of humanitarian law prohibits prolonged occupation. What's more, prolonged occupation remains governed by humanitarian law, supplemented by human rights law, irrespective of a de facto possible annexation. Nevertheless, occupation is understood as a temporary situation. Occupation that is prolonged may lead to a tension between, on the one hand, the obligation for the occupier to maintain the status quo ante, on the other hand, to ensure the well-being of the occupied population. It is this tension and its legal consequences that I'd like to deepen within the framework of this oral submission. To do this, I'll begin by generally addressing the prolonged occupation and the challenges it poses from the standpoint of humanitarian and human rights law. Next, I'll analyze three concrete areas illustrating this tension, the need to interpret and apply contemporary international law in an evolving and systemic manner to ensure protection and well-being of the population. The concrete areas addressed are firstly the legislative administrative competences of the territory, secondly access to items that are indispensable to the survival of the population and protecting dignified life, and lastly, use of force in occupied territory. Allow me, first of all, to address the legal challenges posed by prolonged occupation. The rules of the law of occupation were not developed to regulate situation of occupations lasting several decades. They're based on four fundamental principles that underscore the necessary temporary nature of occupation and to establish a balance between military and humanitarian necessity. Firstly, the occupier doesn't acquire sovereignty over the territory he occupies. Unilateral measures calling into question the territorial status quo are therefore never admissible. A modification of the status of occupied territories can only be envisaged within the framework of a negotiated solution. Secondly, the occupier must maintain the status quo ante and not take measures that might lead to permanent changes, in particular from the social, economic and demographic standpoint. Thirdly, the occupier must maintain security and public order in the occupied territory and administer it in order to ensure the protection and well-being of protected persons. Fourthly, the occupier must not exercise his authority for the purposes of serving his own interests, that of his territory or his population. Within the framework of a prolonged occupation, tensions might indeed appear between these four principles. For example, the well-being of the civilian population might necessitate changes to the status quo. In this context, there's a need to distinguish clearly unlawful situations that undermine the status quo, such as, for example, settlements, from those where the status quo would in fact be maintained to the detriment of the population of the occupied territory. In this case of a prolonged occupation, it is vital that the maintenance of the status quo should not be understood as a freeze on the situation, but as signifying that the populations of occupied territories must continue to be able to live a normal as life as possible in dignity. Occupied territories must not remain frozen in time, but be able to move with their time. To address the legal tensions and challenges specific to a prolonged occupation, it's important to recall the function and the purpose of humanitarian law are to protect and ensure the well-being of the population and not to justify intrusive measures in the interest of the occupying power. The obligation of the occupying power to ensure the well-being of the occupied population calls for an interpretation in favor of the higher interests of the population living under occupation. In order to resolve the tension between the aforementioned principles and better determine the legality of measures taken by the occupier during a prolonged occupation, I suggest three criteria derived from a combined interpretation of humanitarian and human rights law. Firstly, the adoption of specific measures going a priori against the obligation of maintaining the status quo to serve the interests of the occupier is not admissible except for overriding security reasons and as long as the well-being of the population is not affected in a disproportionate manner over the long term included, secondly, specific measures running counter to the obligation to maintain the status quo can be adopted if they benefit the population of the occupied territory, consistent with human dignity, and take account of the wishes of the population in the occupied territory and its historical and cultural specificities. Lastly, thirdly, the adoption of such measures is statutory when these measures amount to parallel obligations of humanitarian and human rights law. If humanitarian law was specifically designed to govern situations of armed conflict, it remains that human rights remain fully applicable in situations of occupation. The Fourth Geneva Convention compels the occupying power to assume active responsibility for the well-being of the population under its control. This obligation to protect the population under occupation and to promote its well-being is concretized in the obligation to respect, to protect, and to fulfill the human rights of the occupied population. The characterization under humanitarian law of lex specialis must therefore not be construed as meaning that this law overrides human rights. In principle, there's no direct contradiction between the obligations arising out of humanitarian law and human rights law. On the contrary, humanitarian and human rights law are mutually reinforcing. Thus, Article 27 of the Fourth Geneva Convention requires that the fundamental rights of protected persons be respected in all circumstances. It proclaims the respect of the human person and the inalienable rights of its fundamental rights. In the event of prolonged occupation, the relevance of human rights is all the more significant. The logic of humanitarian law is aimed at immediately ensuring the essential minimum needs of the population. This must be supplemented by the need of ensuring over the long term a dignified life. Thus, the balance between humanitarian and human rights law fluctuate with the prolonged character of an occupation. The longer the occupation is prolonged, the more the respect for and guarantee of human rights are important. To close this part, I'd like to stress that all actors exercising de facto control are also bearers of obligations at Israel's side. The practice of UN organs recognizes that, at minimum, an armed non-state actor exercising the governmental type functions or controls, in fact, a territorial population must uphold and protect the human rights of the inhabitants. Palestine, having notably ratified Covenants 1 and 2 of the UN relating to human rights and the UN Convention against Torture, has the positive obligation to take all measures in its power and compatible with international law to assure to persons living in these parts of its territory the rights guaranteed by the Convention. Israel and Palestine are under obligation to cooperate and support one another and not to weaken one another in their efforts to ensure the well-being of the population. Victims must also be able to seek reparation for violations or abuse of their rights, whoever the actor at the origin of their grievance, in order to ensure effective respect of human rights. These various actors must cooperate by taking into account that the scale of their obligation will vary notably of the control they exercise and the resources available to them. I come now to the concrete areas, starting with that of legislative and administrative competences of the territory. By virtue of the principle of maintaining the status quo, the occupier cannot take measures bringing about permanent changes, in particular the social, economic and demographic standpoint. The occupier must restore and ensure as far as possible, public order and safety while respecting, unless absolutely prevented, the laws in force in the country. However, by virtue of Article 64, paragraph 2 of the Fourth Geneva Convention, we can deduce that the occupier might introduce new laws if these are indispensable to ensure A, the security of the occupier, B, order of public life, and thirdly, respect for humanitarian law. Though human rights are not in the exceptions of maintaining local law, an updated reading of humanitarian law requires that their respect be guaranteed. Thus, in the case of prolonged occupation, the obligation to ensure public order and safety implies that the occupier administers the territory in such a way as to ensure protection and well-being of protected persons, not only respect and protect, but also provide them with a right to a dignified life. This, of course, means that he has to move away from the status quo. Mr. President, members of the court, the adoption of measures such as planning, zoning, contradicts the previously mentioned criteria. This regime contributes to put in place a coercive environment, aggravating the risk of forced transfer. Aside from the fact that this regime calls into question the territorial and demographic status quo by promoting Israeli settlements, it cannot be justified under security requirements because it excessively affects the well-being of the population and is discriminatory. In the event of prolonged occupation, the occupier is required, on the contrary, to encourage planning and development of the occupied territory as a priority through local authorities and institutions in favor of the local population. This requires, Mr. President, members of the court, a cooperation with local institutions, support and a strengthening of the latter and not their erosion. I will now turn to the second concrete area, that's to say access to vital goods for the survival of the population and protecting a dignified life. Humanitarian requires that the occupier supplies the population with essentials for its survival. The obligation to restore order and public life must be interpreted broadly and designates the various aspects of the life of the population. The occupier is therefore entitled to make changes going a priori against the status quo as long as they're necessary to improving local life. As indicated above, the conditions of existence of the population under occupation are also governed by human rights, which notably, in a context of prolonged occupation, support and reinforce humanitarian law. The occupier must immediately ensure minimum enjoyment of economic, social and cultural rights and refrain from adopting measures that would limit their exercise. Next, with the prolongation of occupation, the obligation to a gradual achievement comes into play. It requires the occupier fully assumes the exercise of these rights in time. Furthermore, by virtue of the right to life, the occupier has the obligation to generate conditions of existence in accordance with human dignity for persons living under his jurisdiction. In the face of prolonged occupation, the economic and social development of the territory may require long-term changes which are opposed to maintaining the status quo. This, of course, creates obligations for Israel as occupying power as well as for Palestinian actors. Mr. President, members of the court, these regressive measures and the use of resources on Palestinian and on occupied Palestinian territory, regressive measures and the use of resources of the occupied Palestinian territory for the needs of the occupier clearly run counter to the previously mentioned criteria. They require modifications of the status quo for the interests of the occupier to the detriment of the Palestinian population. Furthermore, the absence of a gradual realization of human rights is an issue of concern. Lastly, third specific area illustrated in the context of prolonged occupation, the tension between the right of the occupier to guarantee his security, the obligation to ensure the well-being of the population by using the example of the use of force in operations to maintain order. Under Article 43 of the Hague Regulations, the occupier may use force to restore and ensure, as far as possible, public order and safety. However, such a use of force should not be a matter for the conduct of hostilities. Article 43 is but a referral to rules of maintaining order that form part of human rights and the right to life. Maintaining order rests on three principles: necessity, proportionality, and precaution. By way of the principle of necessity, the use of lethal force can only be used in last resort and must pursue an objective goal, such as self-defense or to defend a third party in the event of imminent threat to life. This imminence criteria is strict and cannot authorize use of force preventively. Furthermore, the use of force must always be individualized. A crowd of demonstrators cannot be considered as such as a threat to life. Furthermore, a differentiated use of force must be used if possible. This requires supplying appropriate equipment and weapons for maintaining order, including water cannons, batons, and rubber bullets. By virtue of the principle of proportionality, the degree of force used must be strictly proportionate to the gravity of the offense and the legitimate goal to be reached. Incidental losses are generally not tolerated, and the life of persons who disrupt order must be taken into consideration when weighing up the interest. By virtue of the precautionary principle, law and order operations must be planned with the goal of avoiding the use of lethal force. All this is removed from a logic specific to the conduct of hostility. In the context of occupation that is prolonged, maintenance of order is applied by default. Hybrid situations of civilian and hostile violence must be far rarer than the context of a nascent occupation. Weapons and equipment made available to occupying or security forces must be similar to those which are used by states in peacetime. The use of combat weapons and the use of snipers is even more inappropriate during long-term occupation. The militarization of maintaining order operations must be avoided ex ante when a legitimate legislative and administrative framework must be put in place to regulate the use of force, and the training of Israeli forces must be consistent with international maintenance of order. Ex post, any use of lethal force must be the subject of an actual investigation to ensure accountability, and in the case of proven violations of human rights, there is a requirement to bring those responsible to justice. Israel, as an occupying power, must protect the civilian Palestinian population in the West Bank. The violence exercised by individuals such as settlers towards the population of the occupied Palestinian territory must also be investigated and where appropriate, subject to criminal proceedings. The positive obligation to protect the population from third parties is an essential component of the right to life. In conclusion, prolonged occupation may a priori give rise to tensions between maintaining the status quo, security of the occupier, and the well-being of the population. These tensions are resolved by humanitarian law, supplemented by human rights law. The longer the occupation, the more respect and guarantee of human rights are important. The joint application of these two legal regimes strengthens the protection of populations living under occupation and may impose specific measures that run counter to the obligation to maintain the status quo. Thus, the development of the territory requires the adoption of positive measures in favor of the population of the occupied territory. Similarly, the well-being of the population requires transformations aimed at improving its conditions of life. Lastly, in the presence of a prolonged occupation, the use of force is presumed to form part of law and order. All parties must prevent violence and the resurgence of hostility in order to guarantee a life as dignified and as normal as possible to the population. In this spirit, Israel and Palestine must cooperate and support one another mutually and not weaken one another or erode the authority of the other party. Mr. President, members of the court, this brings to an end the written submission of Switzerland. Thank you for your attention.